We're going to call the next case. It's the matter of Sean Patrick Mount, which is a reciprocal discipline case. Mr. Mount, I appreciate your patience.
Thank you.
Ms. Kate, are you ready to proceed?
I am. I don't have a specific opening, so if Mr. Mount wants to give an opening, he's welcome to do so before I give my case. Or I can give my case as my opening if you'd like.
That probably is the easiest thing. Why don't you got what, your 7 minutes?
Yes, ma'am. Actually, I think this might have been my 15 minutes, but I will try to keep it to 7.
Okay. Yeah, if you could give your case shorter, the better, since we've been here for a while this morning, and then we'll give Mr. Mount an opportunity to respond.
Thank you.
Good morning, and may it please the board. This is a reciprocal disciplinary action brought pursuant to Part 9 of the Texas Rules of Disciplinary Procedure based on Sean Patrick Mount's professional misconduct and probated suspension in the state of Louisiana. Petition for reciprocal discipline was filed in this matter with the Board of Disciplinary Appeals on February 15, 2022. The order to show cause was signed February 16, 2022, requiring respondent to show cause within 30 days of the order why identical discipline should not be imposed. Respondent was personally served with the petition and order to show cause on February 23, 2022. Personal service was accomplished by Tim Berkner, a private process server. Proof of service has been on file with the board since April 8, 2022. On or about November 7, 2018, a joint petition for consent discipline pursuant to Rule 14, Section 20, which includes a joint memorandum in support of consent discipline and joint stipulations of fact, was filed in the Supreme Court of Louisiana in a matter styled In Re Confidential Party, docket number 18B 1823. On January 8, 2019, an order per curiam was entered by the Supreme Court of the state of Louisiana in a matter styled In Re Sean P. Mount, number 2018-B-1823, which states in pertinent part, the Office of Disciplinary Counsel commenced an investigation into respondent's arrest for driving while intoxicated. Prior to the filing of formal charges, respondent and the Office of Disciplinary Counsel submitted a joint petition for consent discipline in which the parties stipulated that respondent violated Rule 8.4b, the commission of a criminal act that reflects adversely on the lawyer's honesty, trustworthy, or fitness as a lawyer of the rules of professional conduct. Having reviewed the petition, it is ordered that the petition for consent discipline be accepted and that Sean P. Mount, Louisiana Bar Rule number 27584, be and he hereby is suspended from the practice of law for a period of 1 year and 1 day. It is further ordered that the suspension shall be deferred in its entirety and that respondent shall be placed on probation for a period to coincide with the term of his diagnostic monitoring agreement with the Judges and Lawyers Assistance Program. Any failure of respondent to comply with the terms of the agreement may be grounds for making the deferred suspension executory or imposing additional discipline as appropriate. Section 3 of the Joint Stipulations of Fact contained in the Joint Petition for Consent Discipline states that the respondent has violated Rule 8.4b of the Rules of Professional Conduct. 8.4b states it is professional misconduct for a lawyer to commit a criminal act, especially one that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. At this time, I'd like to offer the following exhibits. A certified copy of a set of documents in the Mount matter consisting of a joint petition for consent discipline pursuant to Rule 14, Section 20, which includes a joint memorandum in support of consent discipline and joint stipulations of facts, filed in the Supreme Court of Louisiana on or about November 7, 2018, in a matter styled In Re Confidential Party, docket number 18-B 2021-1823, and an order per curiam entered by the Supreme Court of the State of Louisiana on or about January 8, 2019, in a matter style in re Sean P. Mount, number 2018-B-1823. And Exhibit 2, an original certificate from Blake A. Hawthorne, Clerk of the Supreme Court of Texas, dated April 5th, 2022, which indicates that respondent is licensed and authorized to practice law in the state of Texas. Respondent currently resides in Metairie, Louisiana. At this time, may those be entered.
Any objections, Mr. Mount?
No objection,
Okay. Yes. Your exhibits are admitted. Is that all one exhibit or?
There are two. So the first exhibit is all of the orders, and the second exhibit is the Blake Hawthorne certificate.
Okay, thank you. Exhibits 1 and 2 are admitted.
Before I close, I'd like to address a few things that were contained in Mr. Mount's answer to our petition. Mr. Mount states that this board has distinguished the Louisiana Rule 8.4b from Texas's 8.04a2. 8.4b of Louisiana, I've read it, but I'll read it again. It says, it is professional misconduct for a lawyer to commit a criminal act, especially one that reflects adversely on the lawyer's honesty, trustworthy, or fitness as a lawyer in other respects. That particular rule is what Mr. Mount stipulates and admitted to doing in that joint stipulation agreement. I think this is particularly important because he's admitting that he either committed a criminal act, or that he committed a criminal act that reflects adversely on his honesty, trustworthiness, or fitness as a lawyer. 8.04a2 states, a lawyer shall not commit a serious crime or commit any other criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Mr. Mount in his answer states that in the case in re Cardenas, which has been previously cited in the Duke matter, which was decided, I believe, in November, I have that here, but previously decided that there is a distinguishment, it's being distinguished. The two rules are not identical. But in the in re Cardenas case, that case specifically addresses the assault matter, and the language that is quoted is specifically talking about distinguishing 8.4b in Louisiana from 8.04a2 here in Texas. I think that's an important distinction that he's perhaps misquoting or misidentifying. The distinguishing factors have to do specifically with the assault, not specifically to do with DUIs. And I think that's important for the board to consider. Specifically in this case, it's not just the DUI, or the DWI, I apologize, the WI, which is mentioned in the joint stipulation. The joint stipulation also states that this is actually the third arrest that Mr. Mount has had for DWI. I think that's important too, because that could perhaps go to show that there is a recurring issue with alcohol-related issues in Mr. Mount's life. The order even says that he has been diagnosed with mild alcohol abuse, that it is currently being managed, but it does exist. I think all of those things need to be stated here, not for me to question Mr. Mount's character in general, but I think they do make a difference from the cases that have been previously observed by this board.
Ms. Cates, are you familiar with any instance in which the board in Texas has found that a DWI is an offense that reflects adversely on a lawyer's fitness to practice law?
I do not currently have that information and I did do some case law research because again, in Mr. Mount's specific case, there is one conviction of a DWI, but there are the 2 prior arrests, so I think this would even be different. I would have to find a case for you that says not just the one DWI counts as reflecting poorly or untrustworthy or those kinds of things. It would require me to find a case where this board has found that multiple arrests and potential mild alcohol abuse do fit those rules.
Is it the CDC's position that DWI conviction after 2 arrests does reflect adversely on a lawyer's fitness to practice law?
What I can specifically tell you is it is the CDC's position as we stand here today that Mr. Mount has violated 8.42 with the 8.4b violation in Louisiana and is therefore subject to reciprocal discipline. All right, thank you.
Mr. Mount, would you like to make a brief opening statement?
I don't need an opening statement. I can kind of dive right into it if that's okay.
Okay, absolutely. I'll remind you that if you want to give testimony, you need to be sworn in.
I don't plan on giving any testimony to the extent that you need to swear me in, to the extent that there's any question, I'd be happy to do that as well.
Okay, if you're not planning to give testimony, then we don't need to swear you in.
No, ma'am.
You may proceed then.
May it please the board, but again, I appreciate the opportunity to be before all of you. Just to kind of start off, I don't take what happened lightly. I'm mortified and ashamed by it. This was 5 years ago. I have had to deal with it professionally, financially, everything. So I say that as a preface to whatever I'm about to say, because I'm not trying to downplay what happened or make excuses, because I have taken full responsibility at every level. But counsel did just point out, I think, the glaring issue, like I pointed out in the response, which is a DUI, and I have not been able to find any case under BODA that would constitute a DUI would be a violation of 8.02, 8.0482, excuse me. It's not a serious crime. It doesn't fit within the definition of a serious crime. I have yet to find anything that would find that a DUI fits within that. Despite what was just represented, and respectfully so, the offense here is a DUI, nothing more, nothing less. That is the issue, and that's why I use the distinguishing factor before 8.4b under the Louisiana Rules of Professional Conduct, which makes any crime. It doesn't have to be anything. And what I also pointed out, and if you look at the briefs that they attached, there was no finding whatsoever by the Louisiana Supreme Court, by the Louisiana ODC, or any agency stating that, one, that this had anything to do with the practice of law, two, that I was not fit to practice law. In fact, the Pine Grove assessment, which I referred to, that I had to undergo through JLAB, that she just referred to, specifically found that this had, whatever they found, had no hindrance on my ability to practice law or my fitness to practice law. I've prided myself from the time I started practicing law 20 years ago to now to try to give the most effective representation to my clients, but not only that, I understand that it is a privilege to do what everybody does, and I can tell you that this whole process has overemphasized that to the fullest. And not only that, but I've always striven to kind of represent myself in the most professional and ethical manner in every respect. But I also point out that under Disciplinary Rule Procedure 9.04, as I cited in the response, imposition of reciprocal defense to imposition of reciprocal discipline if misconduct for discipline in that state is not misconduct in Texas. And as Madam Chairperson, you just pointed out, I'm not aware of anything that states that a DUI would constitute a serious crime under 8.04b. I did point and cite to the Carl B. Duke matter, which this board addressed less than 6 months ago. And I would also submit that that's an incident which involved evading police, resisting arrest, criminal property damage, a DUI, and then also had domestic battery. And I do find it interesting that counsel is trying to distinguish the Cardenas matter, which was relied upon by that board, to distinguish between 8.04A2 and 8.4B in Louisiana, because if domestic abuse and domestic battery is not considered a crime, an offense under Texas law, then I don't know how a DUI would. I would say that that would be far more egregious, in the board in the Duke matter. I think referenced that and relied upon that. And lastly, I did cite that, under 904C, resulting grave injustice, and what I mean by that is I have gone through this for the last 3 years. I've done all the probation. The criminal conviction has been set aside and dismissed. I've done all the probation. I've complied to the fullest. I do have exhibits that I will attach. They were attached to the pleading, but I'll attach it for the record as well, showing that everything has been complied with the ODC. I've never stopped practicing law in the state of Louisiana. I've never had any type of discipline in the state of Texas for any reason at any time, and I've never had anything in any other jurisdiction either before or after this incident, and certainly do not plan to. So based upon all those factors, I would implore you and respectfully request that you deny the petition, and I'd be happy to answer any questions that anyone might have.
Did you have the exhibits that you wanted to?
Yes, and I apologize, I'm glad you reminded me. It's the 4 exhibits that are attached to the response. Exhibit 1 is the order of dismissal from Orleans Criminal Parish District Court of the setting aside and dismissing the conviction. Exhibit 2 is the final report from the Judges and Lawyers Assistance Program showing satisfaction and compliance with the program for the 2 years. Exhibit 3 is the correspondence from Breanne Hemmons, the Deputy Disciplinary Counsel with Louisiana Office of Disciplinary Counsel, stating that I comply with all conditions of probation and paid all costs. And then Exhibit 4 is just a copy of the judgment in the Carl Duke matter, which we'd offer, file, and introduce.
Ms. Cates, do you have objections to exhibits 1 through 4?
I do not.
Okay, exhibits 1 through 4 are admitted. Does anyone on the board have questions for Mr. Mount? Ms. Cates, would you like to put Mr. Mount under oath and ask him any questions?
I would not.
Okay, thank you. Would you like to give a closing, Ms. Cates, or will you stand on your original presentation?
If you don't mind, I will stand on my original presentation.
Okay. Does anyone have questions for Ms. Cates? I just want to be clear, make sure we understand how you argue that this case is different from the Duke matter that we recently ruled on.
I can say that the CDC's position here is that it is different in so much that I don't think the argument I'm making was made at the Duke hearing, and I think it should have perhaps at least been touched upon, specifically because the way Mr. Mount is arguing Cardenas is not exactly accurate, and that in Mr. Mount's specific case, with all of the underlying aggravating factors, that this does constitute a reciprocal discipline.
Don't the previous DWIs, don't they predate the time period he was awarded?
I am so sorry. I did not hear the beginning of your
Don't
question.
the previous DWIs predate the time period that he was a lawyer?
I am not, I know he said he's been licensed 20 years.
I can answer that, Your Honor. Sir. Yes, and those were all disclosed to Louisiana Board of Review, the Texas Board of Review, so that was all 20 plus years ago.
And those were 2 arrests that did not result in conviction, is that correct?
I think it was like deferred, if I recall correctly, and one of them might have been, I think it was, I have to go back and look, because it's been literally, one of them was like 1994, I don't remember the exact outcome, but I think it was something for deferred adjudication, and same with the other one. I think the second one was reduced to something else.
And if I may make a point to that comment, Mr. Cleveland, the State Bar of Texas would not have brought a compulsory or a reciprocal discipline. Well, they couldn't have brought a reciprocal because there was nothing in Louisiana, but there wouldn't have been even an option for a compulsory because they were not convictions. So that's why nothing to deal with those has been brought before this panel on any of those
I thought you
cases.
were arguing that those 2 priors were incidents that the board should consider as aggravating factors.
I do. I think that they should be aggravating factors to perhaps go to some kind of continuing problem that would then lead itself to the necessity for the reciprocal.
Awarded in 2000, correct?
2000 or 2005?
I think it was 2000. So.
Yes, sir.
Any other questions for Ms. Cates or Mr. Mount? All right. Thank you both. Again, appreciate your patience, and we'll take it under advisement.
Thank you.